Hi guys, Alina Sholtsova, immigration attorney from New York is here. Today we're going to have our live on the most recent immigration news. I'm going to talk to you a little bit about prosecutorial discretion. There is a lot of discussion, many questions about it, and I'm going to talk to you. I'm going to share with you information that I know about it, basically how long it takes, in what situations it makes sense to file this request, and when it may not make sense for you to go for something related to prosecutorial discretion, and if the government may exercise it on its own. I'm also going to talk about recent TPS designations and the most recent one for Cameroon, and we're going to talk about policies related to USCIS interviews. So thank you very much for joining me. Say hello. Hi, Paco. Let me know where you're watching from. Save your questions. Type them up in our chat so I will be able to answer them as well. Hi, Mike. Nice to see you too. Hi, Mohammed. And I'm going to start the presentation. Again, we're going to talk about mainly questions related to removal in immigration court, prosecutorial discretion. As you may be aware, recently the government issued another memo, and I had videos about that as well. We call it the Doyle memo about the prosecutorial discretion in immigration courts. This relates to everyone who is in immigration court who had a previous order of removal as well, even if it was, for example, withholding of removal or order in absentia, or just a removal order that you received as a result of not being able to win the relief you were filing for. Or maybe you are someone who is being placed in removal proceedings now and you're waiting for your first immigration court, let's say master hearing, or maybe you're waiting for individual hearing, whatever is the case. Or perhaps you don't have a date at all. So there are many people right now who are waiting for the court dates. The cases were descheduled, hearings canceled, and now if you check your calendar, you see that your case is pending, but you don't have a date. So this particular piece of my presentation is about you guys. Prosecutorial discretion, it's not really a specific relief. It's something that you may ask the prosecutor for, or the prosecutor may exercise it on their own. So the memo actually says that you don't even have to ask the prosecutors for help. If they believe your case this is not a priority, they may exercise it on their own. What is it that they can do with your case? Well, they can dismiss your case. Dismiss meaning you're going to be out of the immigration court, and we're going to talk about it, whether or not it can be good for you. And or let's say they may ask the judge to administratively close your case. Maybe they will agree with your lawyer to administratively close your case, or it may be other things. It may be stipulation for relief, which I also spoke about in my previous videos, which I have not seen yet, but perhaps soon we will, is when both parties agree that you are entitled to relief, and rather than dragging you through trial, the court would issue an order saying that it's confirmed that you are entitled to this relief. It can be something else. Depends on what is it that you're asking for. So when people consult with me, I always say, especially if they come for a second opinion, I always tell them, you need to know what is it that you're asking for and what the consequences of that request would be. So for example, if you ask prosecutor to dismiss your case, it means all pending reliefs, all reliefs that you filed with the court, for example, you refiled or renewed your asylum claim, will be stopped, right? It also means that if you were receiving that asylum-related work permit, you're no longer going to receive it as well. It's true that you no longer will be in immigration court proceedings, but you're not going to get work permit as well. It may be very relevant to some people, right? Or if you're asking for an administrative closure of your case, you will be able to extend your work permit, but you still be in removal proceedings, only they will not be active. So there is a big difference. And when you make decisions with your lawyer to ask the prosecutor for something, you need to know the consequences. It's extremely important. Some people who already have orders of removal may want to hire an attorney to see if the prosecutors now are going to agree to reopen their cases. Mixed results. Usually, they would agree if you have very strong humanitarian case, almost like you're arguing a waiver. And they will agree if you have a military family member. Okay, that's very, very important, especially if you have a family member who is in the military who may sponsor you for, and you may receive parole in place. Usually the prosecutors will agree to reopen your case. What it means is that rather than fighting for that motion to reopen, I mean, you still have to put the request together. Of course, your lawyer still has to do a lot of work, but the judge will be more likely to grant a joint motion to reopen. Basically, if the government joins, I've never seen a judge, even though I've heard rumors that it's still possible, I've never seen a judge denying reopening of the case. Okay, so that's what it is with the prosecutorial discretion. How long does it take? People ask me, so how long will it take? Does it take 90 days, 30 days? Well, it also depends. Sometimes you file a request for prosecutorial discretion and hear back from the prosecutor, assistant prosecutor, almost immediately, like within a week or 2 weeks. They're ready to dismiss or terminate the case. And sometimes it takes much longer. Sometimes we're waiting and waiting for months to hear. The most recent one I filed was more than a month ago, and I just followed up with the prosecutor, and they told me it's still under review. Maybe they're waiting to exercise their new authority after April 25th. So I hope so. But again, it depends on the office. It depends on the case, on the prosecutors. But I wouldn't be able to promise, I will not be able to promise anyone some specific time frame as to how long it would take a prosecutor to answer that request, especially because they don't really have to. That's another thing. They don't really have to respond. However, in New York now, they have to kind of respond because at 26 Federal Plaza, the judges require now that prosecutor and attorney deliver position on prosecutorial discretion at least 3 days before the trial. So this is good. This will make them actually do something and review the case, not on the day of the hearing. And I don't blame them for anything because they're extremely busy. As you understand, 1.5 million cases are pending, and there are not hundreds of thousands of prosecutors. So one person there is extremely overwhelmed. But at the same time, perhaps if we had some, if it would be possible to impose some sort of at least soft deadlines, it would be great for people and respondents and the court as well. So that's what's happening with the prosecutorial discretion. I think it's a very relevant tool. I think many of you may be able to benefit, especially if you filed for asylum a long time ago and recently you found yourself in a situation where you were transferred to court, but you may have not such a strong asylum case. However, you do have strong family and business ties in the United States. You should discuss with your attorney filing that request. And it's true that you don't really have to file because prosecutors now have to review your case on their own. However, filing something does help them to organize the file, to see through their arguments, to see through some obvious information and beyond the notice to appear. And you may benefit from it. Even if you have to pay extra for it to your attorney, I would strongly advise you to talk about this because it may really help your situation. Again, the solution may not be perfect because, of course, you're going to be probably giving up your claim if you're asking for administrative closure, but you will be saved from removal and you may if we're talking about administrative closure, and you will enjoy the benefits of the employment authorization. And later on, perhaps your situation will change and you will have something more or less subjective to file for, like adjustment of status. So it depends on your situation. It really is worth exploring. Cameroon TPS, great news for nationals of Cameroon. If you resided in the United States as of April 14th, 2022, you will be able to file for TPS or temporary protected status, just like nationals of recently designated Afghanistan and Ukraine. It's true that as of today, they still cannot file their applications. I hope within the next couple of weeks, Afghanistan and Ukraine will be able to proceed with their applications. We're waiting for that official notice in the registry to go forward with applications. And TPS will be great solution for those of you who are, again, facing removal, who already have orders of removal. If you entered legally or without inspection, you can still file for TPS. The only people usually who are disqualified for TPS, those who cannot prove good moral character, all right? Good moral character, and if you had some criminal convictions. Otherwise, I think it's fantastic news. We hope that some other countries will be designated or perhaps redesignated for TPS as well, just like it happened to some, I believe El Salvador was redesignated for TPS, meaning that it was designated a long time ago, and recently they renewed the designation, allowing people who entered recently to file for TPS, rather than demanding that you have to show residence from 1992 or something like this in the United States. So that's, of course, a great way to allow some, it's called temporary status, but honestly, they give it for 18 months, but then the government always extends it. And just looking at the situation in the world, I don't think that situation in designated countries are going to change anytime soon so drastically that it will be possible to stop the designation for TPS. It means, in other words, that most likely this temporary status will be quite a permanent solution. I don't know if it's good or bad. I mean, bad only in case that some people are in this TPS situation for decades, right? And it's bad that there is no direct pathway for citizenship or green card to people who have TPS. But it's great in terms of, you're going to be safe from removal, and it's a solution, some sort of a solution than none. You will be able to get work permit and advanced parole if you are granted TPS, which is great. You'll be able to travel overseas and safely come back. Again, do not know anyone who was not allowed into the United States when they travel on advanced parole. However, it's possible. Every time when you receive advanced parole, you see this warning that it does not guarantee parole into the United States. But I personally do not know anyone. Perhaps there are such situations when maybe there are some criminal accusations and person is not allowed. But I personally do not know, never met anybody, and never heard any lawyer telling me, sharing credible account that someone who had advanced parole was not able to enter the United States. And finally, USCIS. More and more, USCIS is changing its Trump-related policies about the interviews and green cards. Now they basically announcing that they will not be calling you for the second interview related to the second marriage, not second marriage, to the second green card after marriage, when you're trying to remove the conditions on your green card after the 2 years of conditional residency. If you have a good solid case on paper, absent fraud plus strong evidence will guarantee you pretty much that you're not going to be called for the interview, which is great, which is fantastic. We're talking about conditional residents who received their green cards based on marriage. Because remember, there are conditional residents who receive their green cards based on investment as well. This is about those who got their green cards through marriage, family-based immigration. Great news. Employment-based green cards, also very often interviews are waived. VAWA cases, almost all VAWA cases, guys, interviews are waived. You will be called for the interview only if there are some issues in your case. Something is happening, so usually the interviews will be waived. If you receive a notice asking you to produce a medical exam, usually it's a good indication that your green card will be mailed to you rather than you will be called for the interview. Just a little tip. So maybe too early to celebrate, but it's going to be a good indication that probably interview is not going to take place. And now, if you guys have questions, I'll be happy to answer them. Oh, we have a lot of people. Hi, Paco. I'm watching from Togo. I know Togo. I have some clients from there. Hi, Ali, watching from Chicago. Update about essential workers on undocumented immigration. You know, I wanted to share, but I don't have too much to talk about it. However, I saw in the news the Democrats and Republicans woke up again and saying that they will try to pass immigration reform by November. Why by November? Because elections are coming. So we really have a good momentum here to advocate for immigration reform because it seems both parties are interested in passing something this time just because they have to. You see, I feel like momentum was lost at the beginning of the year when they were negotiating the budget and everybody got distracted watching Russia and Ukraine situation. And we kind of got forgotten with our immigration reform issues. But now, with elections coming, I think we have, again, very good opportunity to be able to advocate actively for immigration reform. If I had to guess, and I'll be honest with you, if I had to guess who may benefit from it, I would say that they're really interested in agricultural workers. They're really interested in dreamers, perhaps also TPS workers, TPS holders. And if I had to guess, I would say TPS, not every TPS holder, but those who have been TPS holders for a long time, maybe minimum for 5 to 4 years. So this would be my best guess as to who will be able to benefit from this potential immigration reform that they're discussing. I may be wrong, right? I may be wrong, but that's what I think they will have in mind. Dreamers represent a huge pool of applicants that basically Americans just cannot prove it. They were raised here, have American education. Many are working and contributing, paying taxes. Just recently, American Bar Association published some article that I think $5 billion in taxes was paid by those who have those tax ID numbers. Means undocumented people, those who don't have socials, right? And dreamers, of course, do have socials, but that gives you a clue as to what's happening in the economy, and it also gives you a clue as to who the parties will be interested in. They're interested in taxpayers, interested in long-term residents in the United States, and I think this will be their focus. And they have to have something for agricultural or farm workers. Essential, I'm not sure. I'll be honest, because I do not know. I haven't seen much about essential workers, unfortunately. The momentum, I feel like, was lost a little bit for essential workers, but maybe we'll see something. It's absolutely unfair. I don't think it's fair, but that's the reality that we're dealing with right now. Hi, Marha Kelson. When's it going to start with asylum interview? Asylum interviews keep happening, guys. People are being called for asylum interviews, especially those people who filed their cases recently. I know for a fact someone who submitted their asylum case in January is going to have their interview at the beginning of May. This, of course, recent submissions. I know for a fact people who filed asylum in 16 and early 17 are being called in New York for the interviews. So they do call old cases as well, or older cases, but on a smaller scale. About 30 to 40% of all the cases that are being called for the interview are cases that were filed previously. I've heard somebody from 2015 was still waiting, but I'm not sure if it was in New York. But most cases in 16 and early 17 are being called. They are calling people. Hi, Shofo. Is TPS a legal status, and can you change status from TPS? In USCIS manual, it says that TPS is lawful status. Lawful status. Can you change TPS? Usually you can't. Why? Because many people who would qualify for TPS had a hole in their status before they received TPS. And TPS does not change that previous situation with your status. For that reason, you will have trouble if you'd like to adjust status, for example, for 245C bar is going to be in your way. But if you didn't have, my understanding would be that it should be possible just because they call it lawful status. However, it doesn't really work this way. I'm not really sure why, but USCIS took this position that TPS is not really a status, it's not really an admission. They don't want to give you a green card if you were granted TPS. You know, it's complicated. If you have a specific situation, I would say consult with an attorney and see if in your particular case you can do something. Recently, there was a court case, huge victory. You may recall the problem with TPS and advanced parole travels when they said even if you traveled on advanced parole after you received TPS, that advanced parole could not be counted for your green card case to satisfy the requirement of being paroled. That's why. I do not know. See, not even every court agrees on what TPS really is. Some courts say that it's absolutely a status, just like F1 visa or E visa. And some courts say it's not. It's more like a deferred action, just like DACA people receive something. They cannot change DACA to anything. It's a deferred action. So I would say that it's going to depend on your specific situation. And if you, let's say you were a student, right? And then you received TPS, and then I think it will be possible for you to change it to something, all right? If there is no gap in status. But this is my understanding of the world at this current moment, because USCIS manual says it's a lawful status. So you can open it yourself and read it. Hi, Mohammed. After asylum interview, how long they mail your asylum decision in New York? It depends. Usually they would do it within a month, right? But it may take much longer if there are some checks. I'm letting you know. So sometimes it may take a long time. Yes. Hi, Mike. I'm Ukrainian asylum seeker from LA, and I have a question. I've applied for an asylum in 2016. I moved to LA in early 2020 and transferred my case here right away. Yes. Received the confirmation letter. I still haven't been called for the initial interview. Right, Mike. You know what happens when you change your jurisdiction, right? So Ukrainians, I'm from LA, have a question. Moved to LA in early. Where did you move from LA? Sometimes when you move from one jurisdiction to another, you're actually going to be how to say, put an end of the line, I guess. Your case is going to be taking much longer. But this is my advice to you. Right now, you can ask to expedite your interview, all right? Because of the situation in Ukraine, you have a right, not a right, but you have good grounds to expedite your interview. So if I were you and you would like to receive your interview faster, I would advise, I cannot advise you because it's not a consultation, okay? But maybe discuss it with your attorney. It probably will be a good reason for you currently to ask to expedite your interview, okay? Because if you move from one jurisdiction to another, usually, guys, it's going to slow down your case, okay? If you move from one jurisdiction to another. Very, very important. It's true not only for asylum cases, it is true for other cases as well. Just so you know, moving will slow down your case usually. Is there a bar on F1 visa overstay? Not really sure what that means, but if you're asking about accumulation of unlawful presence time, true wisdom. That's unique, true wisdom. No, there is none. So people who were admitted on F1, J1, I believe M1 visas for duration of status do not start accumulate unlawful presence days only because they fell out of status. It can be very useful for you if you, let's say, overstayed your F1 or J1, and years down the road, you have an employer who would like to sponsor you, and you are able to leave the United States, receive that immigrant visa, and come back without a waiver. Yes. Hi, Hash. Hi, Khalid. We're trying to bring my Ukrainian mother-in-law and 9-year-old brother-in-law who are currently in Poland. All right. So you may refer to, you see, there are some things I cannot talk about live, but you may refer to the Department of State guidelines on this. All right. If you have a mother-in-law, perhaps your spouse has status. If spouse has status, if spouse has US citizenship, you guys can file I-130 and ask for it to be expedited. If USCIS agrees to expedite that I-130, they're going to consider it within 45 days. Then, of course, it's still going to take some time for your mother-in-law to go through this immigrant interview, but it's going to be much faster. It's going to be a matter of maybe several months, maybe 2 months, I would still say, rather than maybe 3, rather than a year and a half, okay, without the expedition. And 9 years old brother-in-law, if it's a brother-in-law, it means that mom has a son, right? So for kids like that, because you guys cannot sponsor the brother-in-law that fast, you may try humanitarian parole. Actually, from here, humanitarian parole that you file with USCIS was designed for a situation like that, when a prospective permanent resident or permanent resident mother-in-law, cannot immediately sponsor minor child. And I have to share with you that currently United States admits Ukrainians at the border on humanitarian parole. You don't have to file for it, but they have to come to the US border and request it at the border. Humanitarian parole is not a visa, just so you understand. It's extremely important to understand that. So it's a less desirable status than visa, than immigrant visa. But that humanitarian parole you can receive at the border, all right? But they have to travel to the United States border. That's about all I can say on live about this, unfortunately. Hi, John. How about TPS for Ukrainians? Right, so Ukraine was designated for TPS, but you can't still file for it. It's a normal situation. We've seen the same with Haiti when the government first announces TPS, and then they have to publish official notice in the federal registry. And after that, once the notice is published, the submission period is going to, the window is going to be opened, all right? So, and you will be able to submit your case. Usually, I believe you get 180 days to submit your application for TPS. Once the window is open, do not wait. I would say submit it as soon as possible. Why? Because it takes like forever to be considered. For people from Venezuela, currently it takes like 6 to 8 months. It's like a long time. Hopefully, they will speed up the processing, but just so you are prepared for the long wait. Hi, Lamara. My I-589 has been waiting in the court for too long because of many delays, postponements of hearings. COVID, yep. I'm waiting for my daughter to turn 21. Better to file for prosecutorial discretion. if you have a US citizen child who is turning 21 and you are adjustable, meaning that you have legal entry, all right, you can adjust, then sure, you should be able to, you should ask for prosecutorial discretion. Okay. Hi, Gagi. Can we expedite I-130 for a child over 21? And can I apply for travel document while waiting for I-130? My asylum case is pending in court. If you're in removal proceedings, Gagi, you will not be able to get a travel document. USCIS does not have jurisdiction over such advanced paroles. And can you expedite I-130 for a child over 21? Do you mean that a US citizen parent is sponsoring the child? Or do you mean the child who is 21 is sponsoring a parent? I'm not sure. So if it's a child who is over 21 and the child is waiting for I-130 to be granted, usually the problem is that you are subject to preference category and priority days. There is no way currently to expedite that. Okay, if you are that grown-up child, no way. Also, you most likely will not be able to adjust your status, even if you expedite it. Well, it's not possible, but let's say your priority date is current. You will not be able to adjust your status if throughout your entire stay in the United States, you did not maintain lawful non-immigrant status. Okay. However, there are some proposals that say that for a fee, you'll be able to expedite that line, that preference category. However, right now, this is not the case, and I-130 will not be able to be expedited, or you won't be able to cut the line, so-called. That's what happens with this. I would suggest that you talk to your attorney and see what other options you may explore. If you're building up the case for potential I-601A waiver, then perhaps administrative closure may be a good solution for you. Maybe. Do not know. Let me see. Hi, Anayo. Hi, Santosh. Any updates on reform? I just spoke about this earlier, so nothing specific so far. We're just waiting. They said that they're interested in passing by November, so we hope so. We hope so. Hi, Julia. How I can expedite withdrawal of my asylum case that I submitted in October 2021. No response from USCIS. I have already got my EB2 green card. Julia, to be honest with you, usually, before the pandemic and all these delays, when a person would get a green card already, USCIS on their own would send you a document saying that your case was dismissed because they found out you got your status somehow else. If you're worried about this situation, you can follow up with the field office. What you can do, maybe involve the congressman, okay? Ask them to see if they can help you, basically saying, listen, I have this situation and I would like to have a resolution, maybe for travel purposes or whatever is bothering you, And congressmen usually are very helpful. They follow up with USCIS. Sometimes when they're very busy, it takes them like a month to do it. But the difference between the congressman and a lawyer is that USCIS doesn't really have any obligations to respond to me, but they do have an obligation to respond to the congressman's office. You see the difference? So usually it helps. Hi, Mohammed. My asylum interview finished, and they said they will mail the decision by mail. Yes, I'm not sure how long it's going to take, sweetie. Usually it takes about a month, okay? But if it takes longer, there is nothing truly you can do unless it takes a very long time, let's say 6 months. Then you can push them to make a decision, okay? But if it takes less than that, I wouldn't be doing anything. Hi, Isha. If a case is reopened and administratively closed, can you get EAD while you are waiting for I-601A waiver to be approved? If your case is administratively closed and reopened, why was it closed and reopened? Well, it depends. Let me tell you what this. Here is a rule of thumb. If you have a pending relief, then you should be able to get work permit. If it's, for example, asylum. If asylum was close to terminated, then you should not be able to. Okay. Also, there could have been some other factors that impacted your eligibility for work permit. You can consult with your attorney, but this would be the main rule. If the relief is pending, and when the case is just administratively closed, the relief usually is still pending unless it was somehow terminated or withdrawn earlier. Okay, that's how it works. How long, hi True Wisdom, how long is the process for my daughter to file for green card? I know live in Mexico, but from Bahamas. Are you a US citizen? And how old is your child? So this would determine how long it's going to take. There is a visa bulletin that tells us how long a person in a preference category has to wait for their preference category to become current. All right? So that usually what affects it. If the child is under 21 and you're a US citizen, there is no preference category. Such a child is considered to be an immediate relative. So we only take into consideration processing times, which may be about a year. Hi, Bukola. They have been postponing my master hearing up to 5 times. What can I do? Oh my God, that's horrible. Listen, what can you do? Why have they been doing that? Is it because the judges are retiring? Because sometimes it's happening. You know, it happened to some of the people I know. They told me that they had these crazy stories where the cases were dragged for forever because the judge was changing all the time. What can you do? Well, you can write to court to advance your hearing date. Your attorney can file a motion. That's about the only thing that you really can do, unless you would like to and have grounds to change your jurisdiction. I'll be honest with you. Okay. But yes, it happens sometimes that you get stuck in this horrible situation when you're waiting for your court, you know, and it's been postponed and postponed and postponed. But there is a motion to advance a hearing date that can be filed, you know, to expedite it. Is it possible to expedite an asylum interview for essential workers in the government? Hi, Andrew. You can ask to expedite your asylum interview for whatever reason you would like. Okay. Usually, I've noticed such requests are positive if you have some medical issue, depression, for example. I've noticed that those requests are being granted. Now, if you are working for the government, I think it's going to be a good reason for you to request for your interview to be expedited if you can show that somehow your status impacts your ability to work. All right, it has to be related to your functions, for example. But remember, when you're asking to expedite your case, it does not mean that it will be granted, guys. All it means that you'll be called for the interview. So please take it into consideration. It's extremely, extremely important, because sometimes you do win your case and you get it from the interview, and sometimes you're referred to court. And sometimes when you're referred to court, your situation is actually worse, right? Because now you're in removal proceedings. So this is something that has to be taken into consideration. Consult with your attorney. But can you? Absolutely. You can present whatever arguments you would like. You know, the law doesn't say, regulations do not say only those people can file. No, you can file if you feel that, you know, you have a good reason for it. Let asylum office consider it, right? Let them consider it and say yes, they agree, or no, they don't. But remember, you will have to, you know, participate in perhaps you will be transferred to removal proceedings. Highly, is there any time frame for administrative process, and what could I do for make my case move forward? Administrative process. Is it administrative processing for a visa? Is that what you're referring to? Yes, you can do something. You can follow up with the consulate, and your attorney can also file a legal net inquiry if there are grounds for that. Right? These are the usual 2 ways. Oh, there is something else. You can sue the government. Yeah, I forgot about that one. I don't really particularly like it, but in certain situations, it's a good option as well. All right. Withholding of removal, hi Simal, withholding of removal situation, file PD, how much long wait and what's after that? Great, we just discussed it. If you're going to play back that video, you will learn that actually there are no time frames for that. And what happens after that, it depends on why you asked for the PD and what is it that you asked. Did you ask to reopen your case in hopes of adjusting your status? Because that's about the only reason why you would ask for it. Sometimes people ask to reopen their withholding cases to again file for asylum if they see that there is a strong argument for changed country conditions. But then, your lawyer should have explained to you what's going to happen. If you're reopening your case, it means you're going to be again back in removal proceedings. And then you're either going to go for a new trial, you're going to ask for another request now to close your case somehow to move forward. So it depends on the plan that you and your lawyer have in mind for your case. Okay. But how long it's going to take, I do not know. Hopefully it's going to take only a couple of months, or maybe you will never hear from them. It happens as well, right? Happens as well. Well, guys, thank you very much for watching. It was a pleasure. Thank you for your questions and joining me today on this Friday night. I hope you're all going to have excellent weekend. And hopefully we're going to have some updates soon on immigration reform. I hope if everything goes well, when it's going to be April 25th and 26th, I'm going to be joining ALA attorneys to advocate for immigration reform before our elected officials in Washington, D.C. And then I'll be able to give you some more updates as to what is it that they have in mind. I hope I will have some information by then. So thank you very much. And if you have not signed up for my channel yet, please do so. And I hope to see you soon.